Hi there, I hope you're doing great. Once again, my name is Mutiaba Conrad, and we are meeting for Contract Law 2. And briefly, today we are going to be looking at a very, very vital topic under Contract Law 2, and this topic is known as Vitiating factors of a contract. So from the onset, I should caution you that it is extremely hard to enter contract law paper and then you do not find a number or two on vitiating factors. So this is a very common area, and please ensure that you follow to the very end. Do not also forget, before you start listening into this video, to subscribe to my channel. Please ensure that you subscribe. Click down on the subscription button and also proceed to turn on the notification. This will help you to always get updates whenever I release videos. This will also benefit you in the long run. So ladies and gentlemen, let's proceed. In today's video, we are going to look at the broader topic known as vitiating factors of a contract. Now, specifically, we are going to look at mistake in this class. However, it's important to note that these vitiating factors generally are divided into 4 categories. But before we go there, what does vitiating factor mean? What does the term to vitiate actually mean? It's an English word, and a vitiating factor is one that may operate to invalidate an otherwise valid contract. So there is already a contract that has been made by parties, but there are some factors that are making it invalid. There is a contract already. Parties have made a contract, but there are certain factors that are operating to invalidate an otherwise valid contract. So those are the vitiating factors. These vitiating factors, please you should note that they are mainly divided into 4 classes. So the first vitiating factor is misrepresentation, and the effect of misrepresentation as a vitiating factor on the contract is that the contract is voidable. The second vitiating factor is what is known as mistake, which we are going to look at in material detail in this video. And the effect of mistake on a contract is that the contract is void. The third vitiating factor is duress. The effect of duress on a contract is that a contract is voidable. The last vitiating factor is what is known as illegality. And the effect of illegality on a contract is that the contract is void. Please, it's very, very important from the onset for you to know the effect of these classes of vitiating factors on a contract. The effect is very important, and you should always highlight it, even in the exam or whenever you're doing a test. You should always tell the examiner what are the effects of those vitiating factors or that specific vitiating factor that you would have identified on the contract. The effect is extremely important. But before we go to look at mistake, it's also important for us to understand when we talk of the term void and voidable, what do we mean? Because a number of times students confuse these 2 terms. So what is a void? When we talk of a void contract, what do we mean exactly? A void contract is simply an agreement made that is legally unenforceable. A legally unenforceable contract is a void contract. Number 2, what is a voidable contract or agreement? Now, a voidable agreement or contract is valid until annulled by the parties. Authority for that position, look at the Black Laws Dictionary 9th edition by Brian A. Garner. It defines it as such. So, for a voidable contract, this one is valid until the parties or a party to it chooses to annul it. Now, having known the background, knowing the classes of vitiating factors, knowing what voidable and void means, knowing the effect of each of those classes on the contract, let us now proceed to look at what mistake is as one of the vitiating factors. In another class, we'll release videos looking at the other vitiating factors. But for now, let's start with mistake, because I believe it's the most commonly set, but also it is the one that mostly confuses students. So, mistake. When we talk of a mistake, remember we have said that a mistake is a vitiating factor. So when we talk of a mistake, what do we mean? What is a mistake? Okay. A mistake, in summary, is an error or misconception or a misunderstanding or an erroneous belief. Authority, Black Laws Dictionary, 10th edition, page 1153. He defines it as such. It is important to note from the onset, that an operative mistake is one which operates to make a contract void. Okay? It is one that operates to make a contract void. Now, generally, a mistake does not render the contract void. Whether or not a contract can be avoided depends on the nature and the seriousness of the mistake. For example, is the mistake fundamental to affect the validity of the agreement? We'll always look at that. i.e., the mistake must have been an operative one. For it to invalidate a contract, the mistake must have been operative. Very important to note. If so, meaning that if the mistake is operative, if it has operated upon the contract, okay, the contract will be void ab initio. From the very beginning, we'll consider it non-functional, as if it never happened. Now, not only will the parties to the contract be returned to their contractual original position, but also any further rights coming from the contract will have no effect, because the contract is treated as if it had never ever existed at all. That is the effect of a mistake. Now, the general rule governing the same was clearly stated by Lord Denning in the case of Soleil versus Butcher. And the rule is, a mistake will not affect the validity of the contract. As a general rule, because the law of contract is mainly based on two principles, and this is the rationale why, on which the general rule depends. It's because these contracts, or a contract, is mainly based on two rules. The first rule is the doctrine of freedom of contract, that parties have the freedom to contract. And therefore, if they enter a contract, no one should interrupt. No one should come in between such a contract. Secondly, the doctrine of caveat emptor. The doctrine of caveat emptor. You will look at it when you're looking at sale of goods. It is another doctrine on which the general rule stands. The doctrine of caveat emptor, that the buyer or that the parties that enter into a contract should ensure that they are not misled. They should take reasonable diligence. Contract law is founded on the laissez-faire capitalist ideology, which operates on the doctrine of caveat emptor, that every party is expected to look out for themselves, for him or her not to be misled. It is not the business of court to protect a buyer who entered a contract carelessly, without minding, sleeping on their rights, that the court should not interrupt such a person when they are making a contract. Having laid out the foundation and the general rule, ladies and gentlemen, let us now proceed to look at mistake a little bit wider. Now, there is what we call common mistake. Okay, we'll be looking at the various classes. One of them is what we call a common mistake, also known as a bilateral mistake. Now, with a common mistake, what you have to know is that here, both parties have made exactly the same mistake relating to a fundamental fact. So here, both parties are mistaken as to something. There are two parties, they have entered a contract, and both of them are mistaken. The other one thinks that this one is meaning A, and the other party thinks that this other party is meaning B. So both of them are mistaken. This one is selling a pen, thinking that he's selling his big pen, whereas the other party thinks that actually for him he's buying a nice pen or any other brand. So both parties here, and a common mistake, both of them are mistaken as to a certain fact. Authority for that position, please look at the Contracts Act 2010. It's very authoritative. Look at section 13E, okay, which provides that consent is free. Consent is free where it's not caused by mistake. So consent must not be caused by mistake. Very important to note. Also of interest is section 17, subsection 1 of the Contracts Act, and a contract of mistake of fact is void according to that section. Please go and look at it. Now, common mistake from the onset, you should also note that there are various forms in which common mistake may appear. Okay, there is what we call res extincta. Okay, this is under common mistake. Now, with res extincta, here, this means basically that the subject matter does not exist. Parties can contract, okay, thinking that actually what they are contracting on is in existence, whereas not. Parties, for example, you may agree to sell to me, let's say your bananas, thinking that they are in existence somewhere you kept them in a store. Whereas unknown to you, as we are contracting, your store has been set up on fire, and the bananas you're selling currently in Kampala are no longer existent. That is what res extincta means, that the subject matter is no longer in existence. Please look at the Sale of Goods and Supply of Services Act. Okay, it provides for authorities for which you should include. Authority for that position, and I encourage you to look at the case of Cauteria versus Hasty. It is a locus classicus on this. It's a case of 1852, 5 HLC 673. The brief facts of this case were that the contract was for the sale of and purchase of grain in transit, which both parties believed existed. The captain had actually sold it, while the parties who were contracting the captain had already sold the grain. When this was discovered, court declared the contract void and rejected the seller's argument that the buyer had accepted the risk and should pay the price. Okay, so court held that the goods were no longer in existence. Now, it's important to note, ladies and gentlemen, that when we talk of res extincta, okay, the non-existence or the seizing of the goods, ceasing doesn't exist. Ceasing to exist doesn't mean perishing of goods, okay, but can also include changing hands from one person to another. So it does not mean that the goods have ceased to exist. But res extincta can also include the goods upon which you're contracting changing hands from another person to another at the material time by when you were contracting. However, there is an exception. Okay, there is an exception on res extincta, and the exception here is contracts of a speculative nature. Now, in case you enter a contract of a speculative nature, this is an exception to res extincta. You cannot then plead res extincta. What do I mean here? Here, there is one party that is speculating upon the existence of something. They are not sure whether it's there or not. But the other party is contracting, believing that actually that something is in existence. Something either that they are buying, they know they are contracting to purchase the same, thinking it's in existence. But this party, the other party who is contracting, is just speculating. They are not sure whether indeed it is res extincta. Okay, so that is an exception. Authority, look at the case of Mercury versus Commonwealth Disposals Commission. It's a case of 1950, 84 CLR 377 HC. It's an Australian case, a very interesting case. The brief facts of the case were that the contract was for the salvage rights of a wreck. Okay, so there was a shipwreck. So the contract they entered was to salvage the rights of that shipwreck. The buyer went to considerable expense to locate the wreck at the approximate position given by the commission, but could not find it. So the commission gave this party the exact location in the sea where they thought that shipwreck was at that material time. So they gave this party the exact coordinates. And this party spent a lot of money, and he did considerable amounts of things to ensure that they actually locate and find this shipwreck. When the buyer sued for breach because they failed, they did everything and employed so many machines, but they failed. Now, when the buyer sued for breach of contract, the commission relied on the principle of res extincta. They pleaded that actually the ship had ceased. It was non-existent. Court disagreed. Court completely disagreed. And court held that there was no operative mistake and the contract couldn't be declared void. So the court refused to declare the contract void. Court said that no, actually you speculated on the existence of the wreck, whereas the other party didn't. And as such, you cannot rely on the doctrine of res extincta. I hope that has been clearly explained. Let's proceed to also look at another aspect. That is, if the goods have commercially perished, the goods no longer have the value that was attached to them in the contract. So there is also another scenario where the goods have commercially perished. Now, where the goods have commercially perished, look at the case of Borrolane and Ballard versus Philip Phillips and Company Limited. It's a case of 1929, volume 1 KB, page 574. The facts here were that the seller had bought 700 bags of groundnuts in a warehouse without inspecting them. He sold them on to another party. When the buyer came to inspect them, 109 bags had been stolen. The buyer refused to pay for them. Court held that the goods had ceased to exist in commercial terms and the contract was as such void. So this is another illustration where there will be res extincta. And this is where the goods have commercially perished in the commercial sense. Let's now proceed to look at another form of common mistake. And this one is res sua. Okay, res sua. Now, what does res sua mean? This means one's own goods, where one makes a contract to purchase that which in fact already belongs to him. So here we are looking at a situation. Before I explain this point further, it's important to note that the contract is void. If there is a situation such as res sua, then the effect is that such a contract is void. Why? Because such a mistake is clearly operative. It has operated to invalidate the contract. If you enter a contract thinking that you're buying a TV that belongs to me, whereas actually unknown to you, that TV was already given to you by your father, or that TV from the onset already belonged to you, then such a contract would be void because the mistake upon which you contracted was operative on the contract. Authority, look at the case of Cooper versus Phibbs. It's a case of 1867 LR2 HL 149. Cooper took a 3-year lease for a salmon fishery from Phibbs. At the time of the contract, both parties believed that Phibbs owned that fishery. It was, however, later discovered that actually he didn't own it. And as such, court held that the contract was void for mistake and that the mistake had actually operated to invalidate the contract. Let's proceed to look at another third element. We have already looked at res extincta. We have looked at res sua. We are now proceeding to look at common mistake as to quality of bargain. What happens in the event that there is a common mistake as to the quality of the bargain? You're entering a contract, you're bargaining, but there is a common mistake. For you, you think that someone is going to sell you an iPhone, okay, whereas actually someone is selling you, let's say, duplicate iPhone. So you're mistaken as to the quality. Now, where the mistake that is common to both parties is the subject matter of the contract, okay, is of quality different to that for which the party anticipated, then the mistake has 3 consequences, okay? The first is that the mistake won't be considered operative. Secondly, it will have no effect in common law. And then thirdly, on the contract, and both parties are still bound by the original obligations. So both parties will still be bound by their original obligations, where the common mistake is as to the quality. This is very, very important to note. However, although the mistake has no effect on common law, court could still set aside the agreement in equity. Now here you have to be a bit very careful. There's been a lot of controversy on this doctrine of setting aside the contract in equity. You look at the case of Sole versus Butcher, it's a case of 1950, volume 1 KB, page 671, on the aspect of setting aside such a contract under equity. But under common law, such a contract would still be valid. When you're looking at this, please look at it together with the case of Great Peace Shipping versus Transvalaris. It's a case of 2002 EWCA CIV 1407 CA. Okay, that case actually has doubted whether there is a doctrine of equitable mistake justifying rescission or setting aside a contract. So there has been a number of contrasting decisions, and please, when you're doing your exam or answering a question, contrast these decisions, show the examiner that you are in the know, okay? Make a proper analysis so that you're able to convince the examiner to give you more marks. Now, of interest also is the case of Bell versus Lever Brothers. Please go and look at that case. It is a very common case on this principle. And also you look at the case of Sole versus Butcher in material detail. Now, let's proceed to look at, we have looked at what a common mistake is, okay? Common mistake. I now want us to proceed and we look at a mutual mistake, okay? We have looked at a common mistake. We have looked at it in detail and seen how it operates and some of the elements under it. Let's now proceed to look at a mutual mistake. Now, a mutual mistake is also known as a bilateral mistake, okay? A mutual mistake is also known as a bilateral mistake. Now, here, under a mutual mistake, both parties fail to understand each other, okay? Both of them fail to understand each other and are at cross purposes as to the meaning of the contract. Both parties have failed to understand each other, and they are at cross purpose, or they both don't understand what the meaning or what the contract actually refers to. Now, when court is handling such cases, courts will apply an objective test to identify a common intent if one exists anyway. The contract will continue. If not, it will be void. If court can analyze and realize that actually there is a common intent between these two parties that we are contracting, then it will let the contract continue. But if the court discovers that actually there is no common intent between these parties, then the court will declare such a contract as void. Authority for this position, look at the case of Raffles versus Wichlass. It's a case of 1864, 159 ER 375. The brief facts of this case are that the contract was for the sale of cotton on board of a ship named Peerless that was sailing out of Bombay. There was a town known as Bombay. In fact, there were two ships that were sailing out called Peerless, and both, actually, interestingly, both carrying cotton, okay? But one sailing October and one in December. So there were two ships, okay? Both of them called the same name, but one was sailing out in October and the other one in December. The sailor was under the impression he was sailing cargo other than the one the buyer intended to buy. Court held that no common intention could be formed. The contract was declared void for mistake. Court observed that actually the mistake was operative, and therefore there was no common intent that could be found between the parties, and therefore the contract was discovered as void. Let's proceed and look at another aspect. Now, where there is an ambiguity surrounding the subject matter, okay, we are going to look at what if there is an ambiguity surrounding that subject matter, what happens? Now, where there is an ambiguity surrounding the subject matter of the contract will be declared void for an operative mistake. Authority, I invite you to look at the case of Scriven Brothers and Company versus Hindley. It's a case of 1913, volume 3 KB, page 564. The brief facts of this case are there were different qualities of hemp. Okay, the auctioneers were selling hemp that was tow is TOW, of an inferior quality. So the quality was inferior. This was not made absolutely clear in the auction catalog to the other party that was buying. And the purchaser bid extravagantly. So he bid with a lot of money, thinking that it was the high quality hemp, under the mistaken belief that it was a superior quality hemp which they were buying. Court held that there could be no reconciling to the mutual satisfaction of both parties and that the contract was void for mistake. However, where one party is merely mistaken as to the quality of the contract, okay, this is different if a party, that is the position of the law. But on the other side, if however, one of the party is merely mistaken as to the quality of the contract, then the mistake is not mutual. Then the mistake is not mutual, and indeed not operative. Okay? The contract will continue, and the court will not declare it void. So it's important to know. Okay? Authority for that position, look at the case of Smith versus Hughes, a case of 1871, LR6, Queen's Bench 597. It is authoritative on the same. Let's now proceed, ladies and gentlemen, to look at the last class of mistake, or another category of mistake known as unilateral mistake. Okay. Now, unilateral mistake, the authority look at the Contracts Act 2010. Look at section 17, subsection 2 is the authority. But what is a unilateral mistake? It's important for us to know it. Now, under unilateral mistake, it's only one party to the contract that is mistaken. Now here, it's one party, not both. Remember the other category of a common mistake we have been looking at. It is both parties. But here, it's only one party that is mistaken. The other party is not mistaken. They are aware of what they are doing. Okay? So it's only one party that is mistaken. Now, if that is the case, and it's only one party that is mistaken, then the contract is void. The effect of unilateral mistake is that the contract is void. Why? Because there is lack of consensus ad idem. There is no meeting of the minds. One person is thinking the other thing. One party is mistaken, whereas the other is not mistaken. Authority, look at section 13, subsection E of the Contracts Act 2010, and also look at section 17, subsection 2 of the Contracts Act 2010, which I already took you through. Now, section 17, subsection 2 of the Contracts Act states that a contract is void where one of the parties to it operates under mistake as to a matter of fact essential to a contract. So even the position of the law under Ugandan law is that such a contract is void. Now, unilateral mistake, as we saw under common mistake, it is also divided into a number of limbs. The first limb under unilateral mistake is what we call mistaken terms. Okay, mistaken terms. I need you to buckle up here, okay, because it gets a bit tricky. Now, the first is what we call mistaken terms. Now, a mistake under mistaken terms, it's important to note that a mistake is operative when made by a party and the other knows of it, or is deemed to know. He may know of it, or he may be deemed to know. Authority, look at the case of Hartog versus Collin and Shields. It's a case of 1939, volume 3, All England Law Reports, page 566. Now, in this case, in a contract, the price of skin was stated to be $10 and 1 farthing per pound. The regular practice, however, was to sell by piece rather than weight. Since there were 3 skins to every pound, this reduced the cost to a third. The buyers argued that the offer was wrongly stated, as would be common knowledge in trade. Court held that the mistake was material and the contract as such was void. So court held that there was a mistake as to the terms of the contract, and court went on to declare the contract void. Important to also note on the sidelines are the elements for unilateral mistake. What are the elements? Okay, for us to say that there is a unilateral mistake, what elements must we always look out for? One party to the contract is mistaken. So there must be one party to the contract that is mistaken. Secondly, the other party knows the mistake. So the other party must be in the know of the mistake. Then also, lastly, the mistaken party must not be at fault. Very, very important. Let's now proceed to look at another category of mistake under what we have been looking at, which is unilateral mistake. Okay, remember we have already looked at mistaken terms as the first limb. Let's now look at mistaken identity as the second. Now, please follow up here very well. This part normally confuses students. I'm going to give it more time. Now, under mistaken identity, and this is a very examinable area. Under mistaken identity, okay, from the onset, please note that this aspect as to mistaken identity, courts have applied this principle in an inconsistent way in different cases. So you'll find many cases where court has applied this in an inconsistent way. But normally here, the common scenario that arises will be when a rogue, okay, or a muyaye, okay, or a rogue, basically a thief, or someone who comes to deceive so that they take away your property. So the common scenario here under mistaken identity is that a rogue has made off with property belonging to another person. So a rogue comes to you, he deceives you, or he presents himself to be a person who they are not, and then they go away with that property. And they go away with that property after making a false representation as to their identity. This then is the mistake made by the other party. Okay? So here there is a rogue who comes to you and tells you that, for example, I am the king of Buganda. Okay? Please sell me your necklace. I'm a very popular person. I'll pay you. Okay? So you thinking that they are the king of Buganda because you know the king is very, very rich. So you go on to give them that property. Okay? So they go off with them. The mistake is made by the other party who has given out the goods. And they are mistaken as to the identity of that person. They thought they were selling to the king or to the Kabaka of Buganda, who is very rich and will pay, whereas actually they were selling to a rogue or to someone who misrepresented who they were. Now, normally, the goods will usually have transferred to an innocent third party. This rogue goes and sells these goods to another third party who does not actually know that these goods were stolen by the rogue, from whom the original owner is trying to recover them. Now, the original owner, the other lady or gentleman that sold to the rogue, in this scenario, he's trying to recover them from this third party who innocently bought them, thinking that they were buying genuinely from the seller who is the rogue. Now, these cases of mistaken identity are very frustrating. Okay, they are very frustrating, and also they are distressing, because now court has to choose between two seemingly correct persons whom to disappoint, okay, or whom to give judgment against. Now, if the contract normally as pertains mistaken identity, okay, what you have to note is that if the contract is one covered by the Sale of Goods and Supply of Services Act of Uganda, then the rogue as seller has no title to pass in disposing of goods. You remember the principle under Sale of Goods and Supply of Services Act. You'll be looking at sale of goods, but basically, there the principle is that you cannot pass title that you do not have. Nemo dat quote non habet. You cannot pass a better title than that which you do not have. Okay? If you don't have ownership of goods, you cannot then purport to sell them. Now, if the contract is covered by the Sale of Goods and Supply of Services Act, then the seller has no title to pass to the third party. But if the original owner identifies the title as only voidable sufficiently early enough, then he may have rights as against the third or subsequent purchaser. Also important to notice that if the third party buying the goods from the rogue does so in good faith and without notice of defective title, then he may have a good title as against the party from whom the rogue acquired the goods. That is the legal analysis surrounding mistaken identity. Very important to note. Let me give you an interesting case, and the locus classicus on the same is the case of Candy versus Lindsay, a case of 1873, 3 APP CAS 459. In this case will illustrate in detail what mistaken identity and how it operates. In this case, Blinken, please follow the names, okay? It can get a bit bumpy here. Blinken hired a room at 124 Wood Street. In this street, a highly reputable firm, Blenkiron and Company, conducted its business at number 123, the room. Blinken then ordered for a large number of handkerchiefs from Lindsay's with a signature designed to be confused with that of the reputable firm. The goods were supplied and billed on the firm and were never paid for, of course, because they were not ordered by the firm. Blinken had sold some to Candy before the fraud was actually discovered. Lindsay then tried to recover the goods from Candy under conversion. The House of Lords held that the contract was void for mistake. The cheat never gained true ownership of the goods. That was the holding, okay, from that case. In conclusion, let's briefly highlight. Okay, so basically that's it on mistaken identity. Briefly, let's highlight the basic requirements that the original owner must satisfy in order to claim that he retains ownership. So the original owner, the other party who sold the goods, what must they satisfy in order for them to retain the goods? One, he must show that he intended to contract with a person other than the one with whom he did in fact contract. Secondly, the mistake must be shown to have been material to the foundation, or rather to the formation of the contract. And then lastly, the other party to the contract must have known of the mistake. If the other original owner can prove and show that, then ownership can be given back to them. Lastly, ladies and gentlemen, let's look at mistaken identity and face-to-face dealings. What does the law say? Can you say that you're mistaken as to the identity of someone when you have actually dealt with them face-to-face or directly? Now, where a person negotiates a contract in person, okay, he's deemed to be contracting with the other party who is physically present at that material times of the negotiations. Whatever identity that person assumes, whether they call themselves someone popular, okay, whether that person comes and says, I am Sudil. In this way, the mistake is not the identity, okay, but the credit worthiness of the other person. This is not material to the contract. So the mistake is not operative and the contract cannot be declared void. Please distinguish. I'm going to give you the case of Phillips versus Brooks Limited, the case of 1919, volume 2, King's Bench, page 243. Now, in this case, let me briefly take you through the case, then I will contrast and distinguish the two. Now, in Phillips versus Brooks, North was the name of a rogue who selected jewelry in a shop. He wrote a check of £3,000, misrepresenting himself as Sir George Bolo. North persuaded the jeweler, the lady who was selling the jewelry, to let him live with the ring, leaving the rest of the jewelry till the check cleared. The check actually and indeed the jeweler let the rogue go. Okay. And later on, of course, the check did not materialize, it bounced. The check bounced, and the jeweler found the ring in a pawn shop where the rogue had actually went to sell it off, upon which now the jeweler suing the third party who was in possession of the ring that was sold by the rogue. He argued that he mistook North for Sir George Bolo. That was her argument in court. And of course, that argument failed because court held that he could have only intended to contract with a party whom he met face to face. The pawn shop gained good title. That was the holding of court, that the pawn shop had gained good title because it bought in good faith without notice of any defect to title. Okay, so you see that the decision in Phillips versus Brooks, court reaches a different decision from what I earlier discussed for you in Kande versus Lindsay. Why is this the case? And please distinguish these two cases. And the distinction between these two cases is as follows. One, when you look at Kande versus Lindsay, there was no face-to-face meeting. There was an order of handkerchiefs. The order was sent to an office, the seller thinking that the handkerchiefs are going to a popular company, which was actually on the same building and same floor. So there was no face-to-face interactions, okay? And as such, there was a mistaken identity in the scenario of Kande versus Lindsay. Whereas when you look at this case which I've just discussed for you, okay, that is the case of Phillips versus Brooks Limited. Here, there was, although he claimed that there was a mistaken identity, but court held that no, there was a face-to-face dealing and that the mistake was not as to the identity because you had physically met the person, so you could have examined them and see if indeed they're the persons who they claim to be. So court held that the mistake was not as to the identity because there was physical or face-to-face meeting, but rather the mistake was as to the credit worthiness. Okay, so meaning that the seller of the jewelry was only mistaken as to the credit worthiness. That had this rogue actually, had the check materialized, then the seller would not have claimed a mistake. Okay, so there was only a mistake as to the credit worthiness as opposed to the identity. And as such, court disagreed that there was a mistake as to the identity. A Class A student is expected to make that interesting analysis and distinguish these two cases in a very satisfactory manner. Please do not forget the skill of contrasting cases. And I have just illustrated to you how the contrast of a case can be made. A student who contrasts a case in an examination is a student who will attract more marks. Okay? What we mark in the exam is how is the legal analysis. Because any student can throw around cases, but it takes a deeper understanding of the law and principles for a student to make a convincing analysis. And that analysis comes from a deeper understanding of the law. Ladies and gentlemen, my name is Mutiaba Conrad. Thank you very much for following up to the end of our first class. Please do not forget, subscribe to my channel and also click on the notification button so that you're always able to get notifications of these classes. Thank you very much. Let's meet in another class where I'll take you through duress, misrepresentation, and the other vitiating factors. May the Lord God bless you. Let's meet another day. Bye-bye.